And are you Mr. Pettz?
Yes, ma'am.
Showing you what's entitled application for community supervision or deferred adjudication. Did you review it? Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 10 years in prison. 2 to 20 years in prison and up to a $10,000 fine. Did you, for any reason, your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
According to the plea bargaining agreement, the state recommends deferred adjudication. They're proceeding on count one only. There's to be no contact and restitution, if any. Did you understand that to be the plea bargaining agreement? Plea bargaining agreement, the state is asking that your deferred adjudication be for a term of 8 years. There'll be a TAP evaluation, 150 hours community service restitution, McMilef evaluation, and follow the recommendations in the MRT. Did you understand? Then to the offense is charged in count one. How do you plead? Guilty, not guilty, or no contest?
No contest.
However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
No, Judge.
Mr. Pettz, how old are you?
26.
All right. What are your mental health issues?
I was doing drugs for a little while, and since then I've kind of been hearing stuff and seeing stuff. It hasn't been so bad since I've been in jail, kind of off the drugs, but it was bothering me up until then.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
He's 5.
Okay. Live with you?
No,
Child Protective Services involved?
no, ma'am.
Does the child live with the mom?
Yes, ma'am.
All right, this is what the court is going to do. 8 years deferred adjudication, no contact and restitution, if any, to be a McMilef evaluation while in custody, TAP evaluation while in custody. Follow the recommendations of the McMilef evaluation and the TAP evaluation. There's to be regular reporting by Zoom or in person, proof of employment within 30 days of release. I'm going to want field visits 3 times per month, random, and regular UAs. Anything else you need from the court in order to be successful? Ms. Fergus, can I have a phantom date just so that we can make sure that he's on schedule? And Mr. Reynolds, we're going to give a date just so that we can make sure that everything is happening with regards to his evaluation. All right, so we're going to recall you on July 21st. When you're at the Bexar County Jail, it's not going to show up that you actually have a July 21st date, because if we put that in the system, it will slow down your evaluations because they'll think that you have a court date upcoming. So know that the court knows, and we put it in our system, that you'll be back on July 21st, okay?
Yes, ma'am.
For any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And are you Mr. Pettz?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney?
Yes, ma'am.
Did you the same Joshua Daniel Pettz, who was placed on deferred adjudication in 2021 for the offense of aggravated assault with a deadly weapon on June 9, 2022 for a term of 8 years?
Hmm.
Is that you?
Hmm.
State?
Your Honor, by the condition of the court, Bexar County, Texas, Lieutenant Joshua Daniel Perez, the defendant failed to report to the supervision officer as directed for the months of July and August 2024 in violation of provision of the court.
How do you plead to that? True or not true?
True.
Do you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine? Court will find violation of condition number 4 true. Is there a proposed agreement? Yes.
Actually, it is to grant the motion and to assess 5 years Texas Department of Corrections.
Are you asking the court to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
No, ma'am. I'll be yes, ma'am. Sorry.
Okay. So can you raise your right hand for me, please? And lower your hand. Why were you not successful?
Well, now we know he's a genius.
I mean, you got to figure out why so you won't be back here again. Because 5 years is a lot of time. Any time is a lot of time.
Yes, ma'am.
So what was going on with you that you couldn't successfully complete this?
Nothing really.
Okay. All right. Probation, was there ever any restitution? All right. Defense, is this the agreement?
Yes, it is.
All right. The court will grant the motion, find you guilty. The court will sentence you to 5 years in the prison There's to be no contact with them. Court will give you credit for any time served. There is a $8,000 fine, time and money to run concurrent, and there's an affirmative finding of deadly weapon. All right, we can go off the record. State, you may be excused. Here's the thing. Life will pass you by so quickly. You're going to have to make some changes. Otherwise, we'll be seeing you back here again. And as I tell people, there's always money for the government to find to build a prison to house somebody. And at the end of the day, if there's only supposed to be 10 inmates in the cell and they have to put 20 in it, they're going to put 20 in it. You understand? All right. Good luck to you.
Ashley Clark, 22 CR 216, Mr. Fosgrove.
No. Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well, and that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Does anyone promise you anything or threaten with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want a contested hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab them real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
Call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes,
And what was the result of that UA sample for Miss Clark?
it was positive for methamphetamine.
So her UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No,
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Miss Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
Right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
No.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying.
I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed.
First of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court. So I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right.
So that was that. I thank my subscribers for staying to the end. I appreciate you guys choosing me to hang out with most every day for 20 minutes or so. I really am humbled by you guys doing that. And I really like that. What I read in the comments by my subscribers, when I get it right, I really, really do. It makes me smile. And hopefully, every now and then, I can do that for all you guys too. So until then, stay safe and I'll see you guys tomorrow. And if you are looking for another episode that has all the boring stuff cut out and gives you just the good stuff, then here a couple that may interest you. Enjoy.